I actually made out some calls yesterday and got a listing appointment, but after I sent her the Zoom meetup link, I got a message back saying we are unfortunately not going to be talking to you because we already have an agent that is well-versed in probate, and I checked with them. So what would you recommend me doing at this point?
Welcome, extraordinary agents and investors from across the country. Today is Thursday, May 7th, 2020, and this is Mastermind call number 277. We have 10 people in the queue, so let's get right to it. Let's see who's up first. First up this week is phone number ending in 6338.
Yep, that's me. This is Chad. Can you guys hear me?
Hear you great, Chad. How you doing?
Hey, I'm doing good. I'm in California. My questions, just a couple of them, really have to do with the timeline of the probate and the probate process specifically, and I was hoping I could ask those.
Sure.
So what I'm wondering is, here in California, once probate is filed with the clerk, how soon is that first hearing in front of a judge, and is that hearing a typical hearing where the judge, the attorney's going to be there along with the person that's trying to become the personal representative? So the timeline from the filing, and I know this is, first of all, let's assume that we're under normal circumstances, because right now I know everything's up in the air, but under normal circumstances, on average, how long does it take to go from filing to the probate hearing, the very first one, and what does that look like?
Yeah, in most courts, once the petitioner petitions the court, they will go from there. They'll put notice to creditors in the newspaper, and that will start their 4-month clock. And usually within a week or two, they come up on the docket and they have their initial hearing where they get appointed and they're issued letters of testamentary. What we're seeing now in this environment is those are being pushed out as far as 2 to 3 months. And each courthouse is going to be is different. But Bill Gross is one of our subscribers. He goes to the probate court. Well, before pre-COVID, he was going to every single probate court in Los Angeles County. And several calls ago, he reported back in I guess it was in March, they had actually issued continuances through until the middle of July. So the stuff that's being filed now is being pushed out even further. One of the things that, if you don't understand this, you should understand the difference between full authority and limited authority in California, because that can rapidly decrease the timeline. So if someone petitions the court for probate but with limited authority by default, they have to come back to court multiple times throughout the process, and they have to be so they're subject to an overbid process on the real estate part. If they petition the court from the beginning for full authority, which good probate attorneys tend to do, if they're granted that full authority, then they're not sitting around holding real estate for months and months because of a judicial backlog. They can go ahead and liquidate the assets, and the cash can sit in the estate's bank account without carrying costs and holding costs and downward price risk. So as a probate professional, to really bring value, working with the family and working with the attorney to get them in a full authority position in this environment is one of the highest services you could do for them.
Now, by the time we get the lead, Chad, they've already obviously petitioned the court, because that's how we got the lead. If they petition the court, would they be requesting that full authority right out of the gate? Or is that something they do later on in the process?
If they have a good probate attorney, they will. But unfortunately, not everybody has. I don't know if you watched the video with John Fraker and I. If you haven't used alltheleads.com in the top right, you'll see a search bar. Put in FRAKER, and Kat can link this in the show notes. But John and I talked a little about this. Like, he's been a probate attorney for 20 years, and he's never allowed any of his clients to have limited authority because he proactively makes sure that he's doing what's best for the client. And if only every attorney could actually serve their clients at that level, it would be a much better state for you. But unfortunately, a lot of them just don't. And maybe that's because of a lack of professionalism. Maybe they're too busy. Maybe they like billable hours. I don't know what it is, but it's not as common as I think it should be. But I think it's one of the big opportunities to really shine in the eyes of your clients because you can help them save. I mean, in California, you know what the holding costs are. It's oftentimes measured in tens of thousands per month. So it can make a huge financial difference for the family, and ultimately the attorney's probably going to get paid more because there was the net value, the value of the estate was more. So there is incentive there for them to help the family in getting full authority. I'm not sure why the habit is that they don't, but that's one thing that you can really do to make a difference in this with the backlogs that we're seeing, is do everything you can to make the process more efficient for them.
Okay, just a couple of more, just granular on the process itself. During that first hearing, after they file for probate and they have that first hearing, is it likely or is it common that they would be given their letters of authority at that first hearing if there's nobody disputing it?
Yeah. If nobody objects, then they'll pretty much always be appointed.
Okay. And then my last question on this is that let's assume that they were given their letters and they have full authority in California. Now, as I understand it, they have the ability to sign a listing agreement. That's correct, right?
Correct. Even the full authority doesn't have anything to do with the listing agreement. It's the difference is, even with limited authority, they can sign a listing agreement or a purchase agreement. But if there's limited authority, the purchase agreement has to go to the judge, who will order a valuation from a referee, and then at the next hearing they will have an overbid. And that do you understand that process, the overbid?
No, I do not.
Okay, so you'll take the ratified agreement to the judge. The judge will order, it's basically the equivalent of a BPO, but it's a valuation from a referee, who can be an appraiser, can be an agent, a broker. Once that comes in, then the court will say, okay, we've got a contract dated, May 1st from John Doe to whoever, that we will begin the overbid proceedings, and they will open the overbid at a 10% premium. And at that point, it looks a lot like a trustee sale, where you have to have registered bidders have to have 10% cashier's checks on the spot, and then they give them a 30-day window. If you're the listing agent and you get a house under contract, you take that to court, and your buyer gets overbid, you don't get cut out of the deal. You just have a different buyer. Mm-hmm. And that doesn't matter to you because you're representing the seller. But regardless of whether it's full or limited authority, when they have the letters testamentary, they can sign contracts. That doesn't mean they can but if they have limited authority, they need court approval in order to close the real estate. If they have full authority, it looks more like it does here in Virginia or in Texas. You go do what you got to do to take care of the family. The court doesn't have that much oversight at all until the final accounting.
Great. So I think that answers my question. And just for my own absolute clarity, it's your understanding that with full authority, the beneficiary that's in charge, or the personal admin, with full authority can close escrow without the court being involved at all, without the court even looking at the purchase agreement.
That's right. And the funds will not be released to the family. The funds will be released into the estate's bank account. And you either the will needs to waive the fidelity bond, or there should be a fidelity bond in place for that to happen. But again, a good attorney will make sure they don't really need fidelity bonds if they're doing it correctly. But the money will sit in the estate's bank account until all the other liabilities are settled and they go to court for the final accounting, and then they'll have the authority to release that to the heirs.
Got it. Thanks a lot for that, Chad.
All right, appreciate it. I'm going to skip over to the second person in the queue because it's Bill Gross, and I think he may have something to add to what we were just talking about. So my apologies to the first person in the queue. We'll come back to you in just a minute. Mr. Gross, you're up next.
Wow, I got skipped for. Thank you.
You got moved to the front of the line because I recognized your name.
Wow, if only my daughter would be as impressed about that as cutting a line at an important restaurant or bar. Hey, to continue on that conversation, I'm in Los Angeles County, and so I have a fairly narrow perspective, and I know you have customers all over the country. And as you mentioned, Chad, in LA County, we've just delayed out the filings. People who filed today are going to be getting their first hearing date either the end of September or the beginning of October. People who had authority, sold their house, filed for petitions for court approval this week are getting sale dates in the end of September or October, and that's assuming they don't get continued, the court doesn't get backlogged, and of course that all assumes this COVID thing disappears. And so the court's already, losing 2 months being closed, estimating another 3 months delay process. We're like 5 months behind. And you can imagine it causes hardship for families that have houses. They have to maintain maybe mortgage payments or face foreclosure or tax payments, maintenance. And I guess my question is, have you seen any changes in court proceedings that will help make things more efficient? I did talk to a fellow ATL member in our chat or Facebook group, which is great, who did say to me that in Nevada, which I think is Henderson County, Clark County, that they filed a format for overbidding where if you went to overbid, you had to file in paper or format, file online 3 days before, but then they would allow those overbidders to come in remotely, which is very interesting and creates the possibility to continue that process. So I guess my question is, have you heard have you heard of courts changing? Because in LA, it doesn't seem like we're doing anything different. We're just delay things, and it's just obviously affecting my business. I'm wondering if you might know of anything else happening in courts where they're looking to change the procedures post-COVID to speed things up.
So I have called around and tried to. My prediction, like when I was doing Shift Happens a few weeks ago, I said, what could change all this is, and my hope is that courts are scrambling to get secure systems in place where they can run virtual courtrooms. What's really encouraging is that the Supreme Court is now doing that. So there is a model in place. It just has to trickle down into 3,149 counties. So I don't have any proof of this, but what I believe will have to happen just logistically, I hope that we'll open up real courtrooms, but we'll also, in parallel with that, run a virtual environment to help clear the backlog. Now, the challenge there is going to be, just coming up with additional attorneys, additional judges, additional staffs. It's a logistical challenge for every municipality that their tax base has gone to hell right now, so they don't have this, huge budget to work with. So I haven't seen any proof that that's going to happen, but I sure hope that's where we're headed, because otherwise it could take a long, long time and really, really big courts to clear the logjam that has built up over the last 60 days. Mm-hmm. And, there's an increase in bankruptcy, an increase in divorce, an increase in litigation, an increase in probate. Criminal courts have less pressure on them because they've been, relaxed some of that. But so I think they're going to be forced to find a more efficient way than what we've always done in the past in order to clear this. But it's one of the parts of moving forward. But I think it's still too soon to actually know exactly what that looks like. But my hope is that we have a secure virtual court environment that runs alongside the real, physical court that will help us chew through the backlog twice as fast.
The other thing, I guess I was just going to make a suggestion at the risk of suggesting things to my coach, but just to throw out an idea for that I know that people, when I talk to people who are getting into probate, ask for me, is that so many people have probate and probate-related cases in their current databases. And it's such a good time to reach out to our current, and everybody says reach out to your current contacts And it's just a good time to reach out to people we have. And I'm not saying we shouldn't also prospect for new business, but just be aware that, there are people we know who have conservatorships, guardianships, or probate matters, and that if we at least are, if we're taking the time to get the training, with you, which many of us have, we should make sure we talk to people we already know rather than just talking to new strangers on this. Anyhow, that's my 2 cents.
I agree. I mean,
Appreciate
that's
it, Bill.
good advice. And I think one of the things, just you guys heard me talk about Bill before he came on, like Bill stepped way out of his comfort zone and actually attends basically every probate hearing, and he's learned a ton from that. And I think that for anyone listening, like imagine if you have 3, 4, 5 months worth of probate leads. They're sitting at home. They haven't gotten a call from a probate clerk. They probably haven't gotten a call from the probate attorney. They're not sure where they are in the timeline. And they're not being proactive because they're just kind of locked down. We've become good little sheeple. So if you can reach out to your local court, talk to them about the timeline, talk to them about any measures that are being put in place gather any information you can, and then go through and do around the calls and touch base with every family and be like, hey, this is Chad. I have a team of folks here in Roanoke that help families going through probate. As part of that, we touch base with the clerk and during this COVID environment so we can update our clients on what to expect, what's happening in the courts. Give me a call if you'd like to know, what the update is, and leave the curiosity there. And you should expect a pretty healthy callback rate on that. It's extra work. It's a much higher level of service than we usually provide. But it could get you into more conversations and build more trust than you ever have. So you can use this to your advantage, be the resource that they don't have. And it helps the attorneys, it helps the court. You're disseminating information that originated from the source. So all you're doing, what you're doing is benefiting all parties. So it's a great idea to reconnect with all of your old leads, even the ones that shot you down. They may not this time.
Perfect. All right, next up is phone number ending in 6320. You're up next.
Hey, guys, how are you?
Excellent. Looks like you're in Texas, am I right?
Yes.
What's new in Texas? What can we do for you?
No, I got 2 cases that I'm working on right now. Hey, Chad and Shaia. How you guys doing over there?
Good.
2 cases I'm working on right now that I need specific help with. One I actually spoke about in Probate Mastery was that short sale, that reverse mortgage short sale. Mm-hmm. I know you mentioned that you guys got some people that help with that here.
I'll take this one, Chad. I'll take this one. My wife and I, this is Jim. We started a short sale. Yeah, we started a short sale company in 2006, 2007. My wife has long since taken that over. She's done over 2,000 short sales, and she'll do everything start to finish, and she doesn't take any of your commission. I'll give her name out on the call. Might as well promote her a little bit. It's her name is Pam Sullivan, and you can call her anytime at 954-584-0000. 954-584-0000. She almost always gets them approved. There's not much difference other than there's a lot fewer of them out there than there were, back in 2008, 2009, and a lot of them are closing quicker than they used to. But I know she's done a number of them on reverse mortgages, and you say you have a reverse mortgage that is a short sale also? Is that the case? Yeah, actually, those are considerably easier because you don't need to get financials from a deceased person. It's usually just permission from the heirs to move forward. And I know it has surprised her. There's usually not a lot in it for the estate other than doing the right thing and maybe not having an extra debt that the lender might come after them. They probably won't. But it's surprising how many people just don't want mom or dad or grandma's house to get foreclosed, and they will go ahead and let you move forward with the short sale.
Awesome.
So reach out to her, and she'll be glad to help with that.
Absolutely, I have their approval and everything, and I won't waste any more time on that one. Second one is I called somebody the other day, gained his trust and helping him with a number of things. He actually had an offer on the house, and I wanted to help him out with a bunch of other things that he wanted help with. Ends up calling me back a day later, telling me that offer was they were trying to get less money from him. They were trying to readjust the offer. I had him send me the contract. I looked it over. The contract was basically criminal from what they were having this guy do, and I kind of laid it out for him. He was at the point where he already was extremely annoyed, very upset with these people, and wants to essentially get out of the contract and, look for other options. Have you guys ever dealt with anything with somebody needing to get out of a contract? What is your advice on helping somebody get out of a contract when they are the ones that initiated it and they are the ones that don't want to be in it?
So you're saying a wholesaler put it under contract, then came back and tried to renegotiate the price, and that was during the inspection period?
Yeah, the contract had a 60-day close with a 60-day inspection period, so it's just mean. It's just very cruel.
Okay.
And
where are you in that 60 days? You're still inside of the 60-day timeline?
There's about 5 or 6 days left.
No, I wouldn't pick a fight. Just let it expire.
Okay.
They're unlike. Is he okay with the price he originally signed?
Yeah, he is. He hopes.
They're highly unlikely to close. Is the deal? Is it in escrow? Like, have they sent it to a title company or an attorney?
They sent it to a title company. We don't know if it's been secured by security deposit yet, even though they say there's a $1,000 security deposit. There is no language on the contract which says that they have to have the security deposit in by any certain date.
Yeah. Which a good real estate attorney will pick that apart because there was no consideration, but it costs money to do that, and it's no fun for anybody. So what I would say, if he needs peace of mind now, tell him to call escrow and see if title work has been done. I will bet you at about a 99% confidence rate that title has not been pulled, and that will show you their intent not to close. If they have done title, ask them, like, okay, so where are we at on this? Like, when's our closing date? Because if you're 5 days from the closing date on a contract and the title company hasn't reached out to the seller, that probably means they haven't even submitted it because they never intended to close anyways. So you can just tell him to sit tight for 5 days, and on day 5, send them a notice of the notice of default on the contract and say, per the terms of our agreement, you're outside of your closing date. This contract is null and void. I'm moving forward without you. And just make sure he sends them an email or sends them a certified letter, something to say, listen, this is over. Don't think you have a claim to this. And then you can move forward and help him with a real contract.
Awesome. Okay.
And if I were you, are you buying this one, Shaia?
Hopefully buying it or.
So what I would recommend, if you have a sneaky player like that you're dealing with, I would recommend get your contract ratified and do it in front of a notary. So it's not just a contract, it's a notarized contract. Someone watched you and the seller sign it and then go straight to the courthouse and record it against the deed. And that way, if they try to flank you, and even if they do somehow flank you, drag you through the mud, get him under contract, they have to pay you to release your contract off the title. And I've only had to do it twice, but I made $2,000 on both of those because people tried to screw me over and mess up my relationship with the seller. And then I just very quietly sat there until I got the phone call from the title company. I'm like, oh yeah, the deal that was stolen from me? Yeah, I'll take $2,000 to release my lien or to release the contract. So you can protect yourself by recording a memorandum of contract against title. and it costs like $43 here. But you can protect yourself in case they do try something underhanded again.
That's actually, in this particular case, he is just completely on every advice that I'm giving him. Like our rapport is very, very good. But this is actually a question that I wasn't going to ask, but I've had it for a while on how do you secure yourself from other people trying to take a contract from you. So that's great. Thank you so much for that.
Memorandum of contract is what I call mine, and I've used it a few times.
All right. Next up is phone number ending in 2121. You're up next.
Hi, guys. This is Carolyn.
Hey, Carolyn.
Last week I got something weird happen and I got cut off. So I only heard like half of Chad's answer. But I just wanted to real quick touch base on that, and then I had something else, is the protocol for when they tell me we're not selling, there's a plethora of reasons, either somebody's living there or whatever the case. I was putting them in a special call list, and then I was planning on just, kind of like circling back and just like almost like just cold calling them and asking them if they're interested in selling their house. But I was going to take them off of the mailing list. Is that an okay protocol?
Yeah, that's good. I mean, so I think maybe we went ahead and answered this last week, but if they're keeping the house because they think they're going to go ahead and roll it over to the family and then sell it to a family member, it's very likely that family member won't qualify for financing. I would say, in my experience, at least 60% of the time, they want a family member to buy it, but they know so little about real estate finance, they don't realize that person can't just walk in and get a mortgage. They actually have to have good credit. They actually have to have a low debt-to-income ratio. So a lot of times families a couple months down the line will realize, well, Joey's never going to get his act together where he can buy this house, and then they go ahead and list it and sell it anyways. So don't always take it at face value. Find out what their intent is. And and the other example is if they want to keep it and rent it. The best thing you can do is get them to a property manager that you have a good relationship with. That way you remain in the loop. And then you want to put them on your calendar for a 10-month follow-up, because most families who do this, they end up realizing what a giant mistake they made. Even with a good property manager, a lot of times you have tenant issues. So in 10 months, they're starting to get tired, and that's when you want to talk to them. Don't wait the full 12 months, because then the lease could have already expired and they could have already listed with someone else, which may be the property manager.
Right.
So, like, if there's a tenant situation, mark them for follow-up around like month 5 and month 10, whether they have a 6-month lease or a 12-month lease. And then if it's a family member buying the home, I would follow up in the next 2 weeks, month, or 3 months, because a lot of times those deals never come together.
The ones that allowed me to probe them and allowed me to kind of dig a little deeper, they said the house was paid off and that, a family member was going to live there, that kind of thing. So I just felt like I didn't want to delete those people, because I'm like, some point, something's going to happen here. So, okay,
yeah, I mean, at that point, you have a homeowner. You can, and Roger Lisi is one of our longest-term subscribers. He's really good at this. Anyone who he speaks to in probate, he considers part of his sphere of influence. He puts them in his database as somebody he's met and knows he can help. But those specifically, those are owners with 100% equity. That's a good list, right?
Right.
So when they do want to sell, whether it's probate related or not, when they do want to sell, they have 100% equity. So they're great to have in your database.
Yeah, that's what I was thinking. Okay, perfect. The other question I was curious if anybody had any experience with this is transferring the data from, all the leads over to Mojo.
So we have a direct interface with Vulcan 7, where if you just give us your Vulcan ID, we'll actually push them directly into your Vulcan dialer. We don't have that relationship with Mojo. We're open to it.
Why?
So it's going to be a manual export-import now, and I'm sure you've done that with other lists, but there's no API connection with Mojo. But if you are willing to consider other platforms, then Vulcan 7 is built to handle our data, and we have a direct interface with them.
Is there any reason why all the leads couldn't have a direct connection with Mojo? You guys just haven't.
Mojo's never reached out. I've tried to get their tech team to reach out to us. If they would like to build the tool, so would we. So if you wanna submit a support ticket
I'll give
to
them
Mojo.
a call.
Okay, perfect.
I'm calling Mojo after this. Because it doesn't really like transfer very well, because they do have it where you can put like all the things that you want to transfer over. But so the first time I called everybody by hand just to get my feet wet, and then now the second run I put everybody in Mojo through the dialer. But then when that beep goes, it's like it gives you don't know who's the personal representative, who you're calling, who's the deceased. So I'm having to have two windows open, Mojo and all the leads, and then, so it gets a little fumbly. So I'll see if I can convince Mojo to call you.
Perfect.
I'll work on that.
All right, next up is a familiar name, and I saw thank you for the birthday wishes, Renee. I saw your smiling face. Chad, she does what you tell our salespeople to do. She sends a personal little video instead of just a Facebook message on people's birthdays. Really nice. I thought that was very nice touch. Good job.
Good.
Hi, Renee.
Thank you. Now you know what I look
Sure.
like.
Yeah. Do it again. I like it.
Good.
Only on my birthday, though. I'm married, so yeah.
Right. So am I. That's okay.
Okay, good. Go ahead.
I have, so easy question. Does the attorney ever or should they ever pull title? And the reason I'm asking is because this probate that I have now has an abatement on it, and we would have known about that. I mean, I pulled it, but I'm just curious if the attorney could pull it even prior to me getting for probate.
I don't think they normally do. I mean, quite honestly, we should always do preliminary title, but we don't always, because it's just an extra cost, right? But it usually becomes an issue in escrow because that's the first time we pull title. Mm-hmm. But I don't think unless it's a special circumstance. I mean, it's not normally part of their process is to to do preliminary title on the real estate.
I didn't think so, but I figured I'd ask.
Chad, I'm going to jump in there. I actually, on all my probates and estate sales, short sales, anything like that, I've got a relationship with a good attorney and go to him, and I just promise him that I'll send the listing to him. He can at least do that side, but I need title. And they'll usually do that if you have a good relationship with an attorney that you can take that business to when you do sell it.
Well,
and he's pulling a full title report, Bruce?
Yeah.
We're not getting a full title report, but we're pulling the basics, the preliminary title. So it's not going to catch everything way back, but it's going to catch almost everything.
Okay.
And then with that, this is a city abatement because they came by and boarded up the house that's been sitting there for so long. Just in your experience, I know we're going to have to do our own due diligence, but in your experience dealing with a city, I mean, are they just expecting to just have the lien paid through escrow? I mean, they're not holding any kind of no trespassing and this and that, all this kind of nonsense, like we can't get in the house to do inspections?
There are, in my experience, they're extremely rigid on the dollars. So you can't really negotiate those down, but they easily release them. Like when they get their money, they release. It's never been an issue.
And lastly, I posted this on the Facebook page. I hope you saw it because it was kind of funny. But I put a funny little story about you when you get 30 seconds when you're in the bathroom. Will you record Chad's must-read books for financial literacy? I'd love to have like the top 5, top 10. list.
Okay, I will. I've been meaning to get a recommended reading page up for a long time, so yeah, I'll get you a list of
Cool.
good books to go through.
Okay.
I bet I know number one, Blue Ocean Strategy. Blue Oceans. That's the one you mentioned the most. So yeah, that's a good one. All right, next up is phone number ending in 5672. You're up next.
Hey, hi. This is Terry Myers. How you doing?
Hey, Terry. Great, Terry. Hi.
Okay, so this might piggyback on that first question, but I'm still new enough that I'm having to verify things. I do have my first appointment to talk to a lady. I've set her up with an estate sale person now, and appointments at the end of the month for seeing about listing the house. But she has emailed me and said, I asked her if there's anything else I can do, and she said no, but, they're in a holding pattern with the court. I didn't think, she is the registered, person to take care of the estate. I didn't think that they had to wait for the court to give permission before they could actually list the home and put it up for sale. Am I mistaken on that?
No, it's a very, very common misconception. So a lot of times, they're drinking from a fire hose. They're going through a process they've never been through. And it's very common for the personal rep to hear the attorney say, don't do anything until I tell you you're allowed to. And I don't believe the attorneys are saying that. I believe that it's lost in translation, and that's what they perceive it as. I think what the attorney's saying is this process is going to take 6 to 9 months, and, we'll let you know what to do. It's each step of the way. So a lot of times they'll sit for 2 or 3 months thinking they can't do anything, and then they realize what they should have done, and it equals thousands of dollars in holding costs. So you can just nudge them and let them know that as soon as you have the letters testamentary, you have the authority to list. What state are you in, Terry?
Texas.
Yeah, so in Texas, they have the authority to list and sell the real estate. And you have an even bigger advantage there. In certain circumstances, you can carve the real estate out of the probate altogether. So you can go ahead and list, sell, close, and distribute funds. And that provision is called Monument of Title, M-U-N-I-M-E-N-T of Title. And that's you guys have it like an express lane for probate real estate sales. So it's a common misconception in every state, but it's not true. Like if they have the letters, they can list, they can sell, they can list, they can sign a contract, they can take it to closing. They cannot receive the funds, the distribution, if it's not in monument of title. If it's still inside of probate, it needs the proceeds will go from escrow to the estate's bank account. But like instead of sitting around waiting, they could have the asset sold at today's price and have that, then protect that equity in the bank account for the final accounting whenever they do get their next court date. So they are probably costing themselves money by not taking action right now. Okay.
So the main thing is to ask her about if she's the monument of title and helping her get that done. I assume that would be something for her to talk to her probate lawyer on to handle?
Yeah, and it requires that no other debt. It's not every situation that it applies to, but if you have an estate that has no other debt other than liens on the real property, and that basically if they were financially stable and had their bills current when they passed away, then the state will say, okay, well, there's no reason to hold this family up and hold this house up in probate when there's no real debts to be settled. So let's go ahead and carve it out. They can sell it, and then the estate will close up on a different timeline. So if they had judgments or liens or other, like an RV payment, like you're not going to get monument of title on that because there's other liabilities that have to be settled. So they hold the real estate inside of probate for security. But if they didn't have many assets, or if all those assets are paid off, then there's a good chance you can achieve that. And yes, the probate attorney would be the first step.
Okay. So okay. So my other question is, I think on the last call, Chad mentioned, I'm in Round Rock, Williamson County, next to Leander. I'm going to need, this house is probably good, would be a perfect match for a cash buyer. And Chad mentioned that he knew somebody in Leander. And
you emailed me after Mastery, right?
I did.
So I forwarded your email to Aaron. He's an extremely busy person. I don't give out his cell phone number.
Okay.
I forwarded 4 of you guys, like in that area and around Austin. I forwarded him that and asked him to get in touch. And Shaia, who was on the call earlier, he was one. So I'll remind Aaron to reach out to you guys hopefully today. But
okay,
I did talk to him about it, Terry. He just hasn't had a chance to call you, so I'll remind him to do that today.
Okay. One last question. So if we can't get the monument of title, they can list it, they can sell it, proceeds go into the estate bank account. But you mentioned something really fast, a letter of something, if she's got a letter of something.
So when she went to her initial hearing, they called for objections. Nobody objected. The judge said, okay, you're appointed as the executrix. And the letter of authority, like what gives her that authority, is the letters of testamentary.
Okay, thank you.
All right, next up is phone number ending in 0243. You're up next.
Hey, how you doing, guys?
Excellent. This is not Rosa. Your phone number says Rosa, but hello. What's your name?
Yeah, it is Rosa. It's Gabriel Rosa.
Oh, okay. I thought Rosa was the first name. How you doing, Gabriel?
He's like, no. Yeah, it is, but it's just my last name.
Okay. How you doing, sir?
Doing good. One of the things, I was on the role-playing call yesterday, and I wasn't able to do my role-play. And my thing is, we make phone calls, and I wanted to just give it a try with you guys. I know that you guys come at me with a little bit more stuff. I just started doing the probate with you guys, and I know I've been getting lists from you guys for a good minute, but I've been approaching it as an investor rather than a probate specialist. And I'm not that great, but what I would love, I know I got a little bit more training than some people on just, I guess, making phone calls, but not in this sense. And I just want to try to see if maybe giving it a shot and see if y'all could help me out and see what it could do, because I know this is getting recorded and I would love to hear it.
Yeah, Gabriel, we have 7 more in the queue, so if you could maybe just make it an abbreviated one, like maybe get through your introduction, and then if you need more help, contact us afterwards. We can do it one-on-one. How's that?
That sounds great.
Okay. Go ahead.
All right. Hello?
What's your name? I didn't get clear on this. You want to be the agent or the PR?
Yes, I do want to be the agent because I make phone calls. So yes, I do want to be the agent. Okay. Would it be you, Chad? So I would like saying, so hi to you.
You're outbounding. Ring, ring. So you ring, ring. I say hello.
Okay. Ring, ring.
Hello.
Yes, it's Chad available.
This is Chad. Who am I speaking with?
My name is Gabriel, and I'm calling you because we have a team locally that helps family going through this probate process. We help with estate planning, personal property, real estate, and we really try to understand what each family is going through at this time and help them throughout all the situation. Because we know the faster we get involved, the bigger the difference we usually are. And usually that difference is less time and less stress for you and your family. With that said, what have you noticed that have been the hardest for you during this time, besides the COVID, for sure?
I don't just finding time. It's the house is on the other side of town, and everything's locked. Everything's different right now. We just haven't gotten over there. We haven't gotten anything done. The attorney said that we can't do anything until we hear from him anyway. So, if you want to call back in a few months, that seems like that's probably going to be the timeline.
Well, yeah, and you know what? With that said, that's exactly, I know time is what's the essence with a lot of the families, and accumulating fees and all the stress going through all this is one of the hardest things, and that's what we pride ourselves in trying to help you and your family out, trying to get this and minimizing your stress. And, I mean, I know you said the timing is the problem, and how else is there? Is there any other things that are like the big stuff, any big fees, or, what kind of big stress else are y'all going through?
And, Chad, I think why don't we, in the interest of the other 7 in the queue, I'm sorry, I don't want to cut you off, but, you want to give them like a quick critique on where we're at so far? And then if you need one-on-one help, just call us afterwards. Go ahead.
Your intro is strong. Like you did a good job with your probate USP. So you told me who you are, how you got my info, why, and gave me some examples of how you could help. And then you hit me with a question. And I know you're on a public stage and you might be nervous, but you need to clean up some ums and ahs. You're not really confidently delivering it. So you've got all the right pieces in place and you're doing it in the right order. You just need to deliver it a few more times and get to a level of confidence where you take the ums and ahs out. Because you are doing the right things.
Okay. So just with time, so basically that helps me. So just with time, just like you said, whenever I remember seeing some of the mastery calls with you, you're like the first couple months, I was like, So, so we're in that sense. This is changing the script for me and understanding.
Yep. And I was marble mouth for quite a while until I realized what actually worked. I was back on my heels. They owned me in the conversations and I didn't even know it. So you've got like all these mastermind calls, the probate seller interview sheet. You've got the framework there. So you got a really big shortcut. It's just the name of the game for you is repetition. Just until you clean it up and get it into your own words, you won't be comfortable. But in 10 live phone calls, I think you'll be rolling. You'll have great momentum.
Perfect. Next up is Belinda, phone number ending in 1189. Give us a good win, Belinda. You usually have some good stories. You there, Belinda? All right. Belinda is a part-time agent. She's got a full-time job. They must have called her back to work. Next up is phone number ending in 4361. You're up next.
Hi, Chad. This is Arshi. I actually made out some calls yesterday and got a listing appointment, or I should say the first initial conversation appointment, shouldn't say listening appointment. But after I sent her the Zoom meetup link, I got a message back saying we are unfortunately not going to be talking to you because we already have an agent that is well-versed in probate, and I checked with them. So what would you recommend me doing at this point? Reaching out to them on a phone call, or and how to approach them, or just responding back to that email?
I would do the phone call, and I would not even talk about real estate in that conversation. Show them how disinterested you are, but find another way to help them. So you can say, listen, great, there's 1.9 million realtors in the country. Not all are created equal, but it sounds like you found a good one, so congrats. Listen, one of the things we've never seen another real estate professional provide is service after the sale. Well, what you're likely to find is that once that commission check is cut, you won't hear from them. And one of the things we do after the sale, a few of the things that we do after the sale, is we try to make sure the family has a good understanding of what their options are for investing the inheritance. A lot of our clients will establish a 529 college savings plan, health savings accounts, investment accounts. Some of them, we even show them how they can double their money every 4 years by loaning money right here in the local economy, and it's secured by real estate at 50% of value. So it's an extremely safe way to make really big gains if money is important to your family. The other thing that we try to make sure everyone who's ever been through probate, you now know that it costs 5 to 7% of the gross value of the estate. That was a painful realization, right? So we want to know that we've done our part to make sure that families don't have to go through this. Probate is there to protect estates, but it's just like with most things with the government. It can be an expensive, painful process. So we like to know that our clients have a proper estate plan in place, especially having gone through this yourself. You understand that that it's not exactly a fun thing or a comfortable thing or an inexpensive thing. So I'd like to at least offer to introduce you to my registered investment advisor who could help you understand the financial side of this and what your options are, and my legal team who can help you understand what your options are for having a proper estate plan in place so your family never has to go through this again. Could I connect you with those two people? And it gives you a chance to show, and you're not even talking about real estate, but if that agent, doesn't do a good job, if the listing expires, which a lot of them do, then you'll be the first person they call. Worst case scenario, you can hopefully create two referrals out of one person, and you can, just like our role play yesterday, you can get them over to your investment advisor and your estate planning attorney. I find that once somebody has made a decision on another agent, it's extremely hard to get them to change. It was probably another family member who has the most authority, even though they're not the personal representative. They had the authority. They had the social influence in the family, and they pushed their way in and said, "No, we're using my guy. I don't want to hear it." That's the end of it. And that person submitted, and a lot of times that's a sibling that does that. And to fight against that, I've never found much success. What I have found success is continue to help them in other ways that are non-related, that aren't conflicting with the code of ethics. So there's no harm in you as a real estate professional helping them set up an estate plan or helping them understand how to invest in the future. Even if their broker gets mad and calls yours, it doesn't matter. You weren't talking about real estate. There was nothing to do with an agency relationship. But if that agent ever screws up, if they let the listing expire, then you'll get that one, a couple months down the line, you'll get a come list me call.
So Chad, what's the proper protocol when I actually make a call like that? I usually send out my resume the same day, so it looks like moving forward, I shouldn't be doing that. I should just keep at that appointment and send them a Google Calendar link or something. That's what I should do. I shouldn't be sending them a resume or something, because then that kind of tells them that I am a realtor and all that.
That's right. So if you noticed in Mastery, I show you guys my ridiculously simple paperwork, like my appointment package. And I send them nothing between the time they speak to me and the time we meet. I want their gears to be turning, and I want them to see the contrast of me and other people they may be talking to. And I do not give them access to anything unless they're willing to shake my hand and look me in the eye. They don't get the information. There aren't any brochures. There aren't nothing. Now, I take stuff that I leave with them, but in order to get access to the service that I'm providing, you have to treat me like a human, because I'm going to treat you like one. And there's no like a lot of people say, "Oh yeah, can you send me an email? Is there anything you can send me? Send me." And it's just a deferral. Like they're not ready to do business with you. So I want to get in front of them and show them what I'm capable of, and then I am acting in their best interest, and then I'll hand them what I take, whether we do business or not. But they owe me some face time. The only reason I'm on the phone with anyone is to get a face-to-face appointment. And in this environment, obviously, Zoom is the stand-in for face-to-face. But I want all the decision makers to be part of a conversation, so I'm going to withhold as much as I can to keep them interested and keep that curiosity out there. And then I deliver everything in person. That's why I don't have print collateral anymore. Like it's all in my head, and I don't just hand them stuff, because that's what everybody else is doing. And the intent is, if you want what I have, if you want to know what a probate expert looks like, invite me on a call or invite me to your house, and I'll show you exactly what I can do to help your family. And that's been really effective for me. I just continued to simplify and give less and less information outside of a verbal delivery. And I take paperwork to back me up, because I hit them with a lot, but I leave my package with them when I leave the appointment. But I'm usually carrying one piece of paper back, and that's the signed contract.
Perfect. Thank you.
Hey, Chad, we're coming up on 2. Do you have another appointment, or do you want to take one more call?
No, I'm good until 2:15 today.
All right. We're not going to get to everybody in the queue, guys. As always, if we leave you in the queue, we apologize. Just send an email to support, and one of us will call you back directly and answer your question one-on-one. Next, and probably last up today, is phone number ending in 2281. You're up next.
Hi, this is Kim in Northern Virginia. How are you guys today?
Great, Kim.
Good. How are you, Kim?
Good. I'm good, thank you. I had two parts to my question. One of which is almost we're still in the starting out and kind of understand the whole or the bigger picture of probate, but then there's the granular of the leads that we're having, and kind of almost like the kindergarten version of these leads. They've been named as the person who's going to be the administrator, but they're not through the court process yet. Like this is kind of step 1, 2, 3, 4, 5 that is going to happen to them kind of at the beginning. So I know what, like, do I ask them, do they have full authority or limited, et cetera? And then the second part.
So I don't always preface. Well, let's do that one first so I can remember. Okay. I won't forget your next part. Sure. So the full authority, limited authority, that's pretty much confined to Nevada and California. Like there's not many states where you have an overly complicated process, just so everybody's clear on that. When you typically, outside of a COVID-19 environment, as here in Virginia, by the time we get you the leads, you get the mail out, you start making phone calls. In my experience, I've never, and I'm in Roanoke, which is not Northern Virginia, I understand, but I've never actually had one that didn't have the authority when I reached them or when they reached me. And it does happen. I know there were, before COVID, there's some counties in Florida and some in California that do have court backlogs on a regular basis, and sometimes it'll be a few weeks before they have the authority, before they get the letters. But in Virginia, it's usually not a problem. Now, depending on what your court, how your court reacted, like here in Roanoke, we've kept everything open, and we've continued to do e-recordings, and there's not that, there's not that big of a problem, but it's not that way everywhere. So what you may be looking at now is by the time you reach out, they may have their initial hearing date might be a month or two later. So there's a period in there where they don't have the authority to sign a listing agreement. What they can do, they can be proactively moving toward, getting the property ready for sale. So getting the personal property, an inventory of the personal property, getting it ready for a sale. They can't sell anything. They can't finish, but there's no harm in preparing. So staging things in garages or outbuildings, putting a green sticker on what gets sold, an orange sticker on what gets donated, and a red sticker on things the family are keeping. Like there's things that they can be proactively doing right now that will put them at the front of the line when things do open up, because they'll be ready to go to market. Even down to, if you move everything out into self-storage, you have an inventory of it, you get the house cleaned, you get the house staged, you get great photography. You can be very proactive in doing all the little things other than actually listing and selling, other than selling the assets. So you're likely to see some backlog in all court systems, but I think Virginia is going to be a lot better off because we have a pretty simple process. There's not that much court oversight here.
Okay. So basically, and even to dumb it down a little bit ahead of that, when somebody dies and there's no will, then the process is that there's, can you just, this is the three things that happen to get to the point where the the distant cousin that didn't know the person gets named as the administrator. Does that make sense? When there's a will, it's more clear.
Right. And you can if you look up Virginia succession law, you'll be able to read the statute if you would like to see the actual law. But typically someone from the family will come forward and they will say, listen, I'm a cousin and I know that Aunt Claire just died and I'll volunteer to do this for the family. That's what usually happens. If that doesn't happen, if nobody comes forward, then typically time will pass. Like creditors will find out about a death because they got it through Social Security or wherever. They'll submit a claim to a court. That flags the court that, hey, this person died and the person hasn't been handled. We have creditors that need paid. And then they'll usually appoint a public administrator who will try to find out if there's any next of kin. And if a next of kin can be found, then that person can be appointed as the administrator. If not, then the public administrator will finish the process. And it's very rare that you can't find some distant relative to give the inheritance to, but it does happen. And if in that case, it goes into a fund and sits, I think, for a year, and then it's released into the general fund of Virginia. But that's extremely rare.
Okay. So it must be the case, the first one that we have, where we're doing everything that you suggested in preparation. It sounds like the attorney is acting more as a public administrator because my client, or future client, if you will, says he's waiting for the courts to name him, and they're trying to make sure there's no other heirs, but he hadn't talked to him in 45 years. So it sounds like normally what happens if somebody passed, then they go and say, I want to be the official person for our family, and then it gets approved, kind of for lack of a better word. Is that right?
That's right. And and so usually the two most common reasons you'll see a public administrator, or in California it's a fiduciary, but the two most common reasons is what the situation you just described. No one from the family stepped up, so they appointed that person, or there's infighting in the family. There's a disagreement that looks like it's headed toward litigation, so the judge sidelines all the parties and says, sit down, shut up, we're going to do this according to state law, and we're going to appoint a public administrator. Those are usually the two reasons you'll see a public admin or a fiduciary.
Okay, thank you for that. So then the next thing is that, and this is a totally different swing, we're newer, starting to realize, that to really maximize, we had our first call with Bruce, which was great. To maximize our impact, we need to incorporate the letters. So we've got 2 or 3 months now of leads that we had not mailed to. I saw that historic letter that kind of mentioned COVID. What would be your best practice recommendation? We've called everybody at least once, left everybody at least one message. Would it be smart to mail them out and kind of pick up the campaign now? Or, what are your thoughts on that? Because I don't,
direct mail is effective. I mean, we have lots of proof that direct mail is effective up to 24 months. Certainly in the first 6 months after filing, you want to touch them as many times as you can. And quite honestly, the frequency is more important than the copy. All of our letters are proven and have a pretty consistent message, so don't stress too much about picking the perfect letter. Focus more on getting it done, get it in the mailbox.
Okay, great. All right, I appreciate it.
Thank you very much. Great call today, guys. We got to everybody, Chad, and I want to, as I always do, I want to thank each and every one of you 150-plus people that were here. I want to particularly thank the 8 or 9 of you that actively participated, and I want to challenge each of you, take one thought, one idea, one story, or one thing that you heard on today's call that inspired you, go out and put it into practice and come back next Thursday and share your results with the group. Stay active, stay healthy, guys. Make it a great week, and we will talk to you same time next Thursday. Take care.